So in this episode, we'll dive into the current landscape of property claims post-Hurricane Ian, what has been happening, what have we been seeing, and exploring how the passage of time has shaped the legal terrain, discover the ongoing complexities faced by the property owners and the evolving role of attorneys in seeking just and timely resolutions and payment of their claims. So grab your candy, sit back, and join us for the follow-up episode where we continue to unwrap the sweet secrets of law. So let's do our legal disclaimer. The information presented in this show is derived from publicly available sources and intended for general information purposes. It does not constitute legal advice or establish an attorney-client relationship. Legal interpretations may vary, and listeners are encouraged to seek professional legal advice for their specific situations. The host and producers are not responsible for any inaccuracies or omissions in the context, but if you require legal advice or have any questions, especially about your hurricane claims, what your rights are, if you feel you've been underpaid, any of those things, reach out to our office at 727-733-9438. So let's go and remind everybody kind of what one of the area of laws that we specialize in at the Colucci Law Group is we do hurricane claims. And people sometimes ask, what does that mean? And I didn't know. When I went to law school, I had no idea this area of law existed. I didn't know anyone who did it. You don't learn it in law school. And so I fell into it when I was working at Luke LaRoe's office. And Luke LaRoe is just an advocate of the people. He will take, we do civil rights, which just really means that we will take kind of anything that comes in the door, that somebody's being treated unfairly. That is an area of law that we will practice. So somebody had come in, and an elderly man had come in and explained to me exactly what had taken place with his insurance company. And it broke my heart because the problem with him was that he had such a backstory to it. And so long story short, what happened was that he had a residence, and he had two residents, and his second home was in Florida, and he was allowing somebody he felt really bad for live in his mother-in-law suite in the back of his house while he was not there. And it was a guy that was down on his luck, and so my client had let him live there. Well, during the time he had been living there, and my clients were out of the state, he started stealing all of their stuff. I mean, he had slowly stolen every single thing from inside the house and sold it. I'm talking down to the boat he had with all of the propellers. I mean, everything was sold. But the part that really kind of was the heart wrencher was, it's really the things you don't understand about people's belongings and how much their home or the things they have inside of it actually means to people. And so for my client, years prior, he had his wife and his daughter had been savagely, brutally murdered by his daughter's husband. So he literally came into their house when she was trying to get a divorce, and he shot and killed his daughter and his wife. And what he had gotten from the police department after he went and identified the body was they had given him his daughter and his wife's jewelry. And I know this sounds kind of, abnormal, but their blood was still on the jewelry. And so he had said that it was one of his prized possessions that he actually would travel with, and he had left it at his residence in Florida. So long story short is that was some of the items that were stolen and pawned. He never saw them again. And I'm telling you, that was the moment when the guy started to really break down and cry about how much that meant to him. So he's filing this insurance claim. He did all the worked with the insurance company, and then the insurance company were going to pay him for all of his items that had been stolen. And then at the very end, they write him this letter telling him he doesn't have coverage. And when he came to me and asked me, it was, for me, it was the insult to injury. I had already been through so much, and then the insurance company made me jump through all of these holes to make me identify every single piece of belongings we had. Because that's one of the things we know. Is that if you have contents, you have to identify every single thing. Where did it come from? Where did you get it? How long did you have it? What did you pay for it then? What do you think its value is now?
And please give us a receipt, even though you've had it for 20 years.
20 years, yeah. Where's your receipts? Every single thing. They will badger you about every single thing you put on your contents list that you are alleging. So this elderly man had went through all of this stuff, and when he gets to the end, when they're finally telling him they're going to pay, they find some loophole out of pain, and they send him this letter. And so when he comes to me, I start doing the research, and I'm just like, well, there's no way the insurance company lied to you. Like, that was literally, I swear to you that those were, I'm like, I literally thought to myself, it's in black and white in a letter from the insurance company. There's no way it can't be true, right? I'm like, you wouldn't put something that was a lie in a letter to a client. That's really what I thought. Now, sitting here today, we can all say it does happen all the time. It happens way more than you would think. So I started doing the research, and I was always trying to find a way of how can I help people and not charge them. That was really a big thing for me that I was trying to figure out. I wanted to find a way to be able to give back to my community, give back to the people, because when someone comes and sees a lawyer, it's in the worst moments of their life. Mm-hmm. And almost no one can afford what a lawyer is usually charging per hour. It's very, very difficult and adds up very fast. So I really wanted to figure out where I found myself, and someone had told me, your niche will find you, you won't find it. I had a good mentor who told me that. Sham was his name. A good mentor who told me that. And so I was constantly being open, looking for kind of what my niche was really going to be. I knew I was a trial litigator, so I specialized in trial. I could try any case, but what was my area of specialty really going to be? And so when I started researching this area of law, what drew me to this area of law was that I had a history with Hurricane Katrina, helping victims afterwards and helping for Habitat for Humanity. So I was very interested in hurricanes and the aftermath of how much of a need there was for immediate relief afterwards. And then started realizing that people were being taken advantage of in their insurance claims. So when I was researching this area of law, I found out there's something called one-way attorney's fees, which was insane. Like, I was like, one-way attorney's fees, what does that mean? And what it meant was, in essence, Florida was one of the only states in the country, there's very few of them, that say that if you sue your insurance company because they have failed to pay you what you're owed, if they pay $1 after you file a lawsuit against them, they have to pay how much they owe you, and they have to pay towards your attorney's fees. So that was amazing. So that meant if somebody was owed $5,000, right? They repair their property and they send it all to the insurance company. The insurance company goes, no, we're not paying for all of that. We're going to pay for a little bit. Or they just say we're not paying for any of it. And they're owed only $5,000. I was able to represent that person on a contingency, which meant that you don't pay me any money unless I recover. But under the one-way attorney's fee statute, I was able to get them all of their money and then get my attorney's fees actually separate. So that was an insane concept to me. I was like, this is exactly what I want to be doing. Holding the person responsible for what they did wrong. And it made sense. Because if you think about it, in the grand scheme of things, the way that it works is that if you file an insurance claim and then the insurance company either wrongfully denies your claim or underpays it, what you're looking for is the exact money it will take to repair your property. So if an attorney takes a chunk of it, 30, 40%, it becomes very difficult for you to repair your property. And so the one-way attorney's fees statute was huge and was really the reason why I focused a lot of my practice on doing these property damage insurance claims and being able to help people after a hurricane. So now, as we sit here today, the most unfortunate thing has happened to the state of Florida is that that one-way attorney's fees concept has been now erased. So Governor DeSantis and the state of Florida, it was done at the end of 2022, which got rid of the statutory attorney's fees, is what they call it, the one-way attorney's fee statute, which is very disappointing, very disappointing. It broke my heart for insureds who are looking to find an attorney who represent them, because now it leaves a huge hole. Because I want to give people an example, because this is really where they have a hard time kind of understanding it. It's because they don't realize that when we're suing the insurance company, we are suing them for the exact amount that is needed in order to put them back to their pre-loss condition. We're not suing for anything additional. So the one-way attorney's fee statute is really what allowed a lot of these people in order to be able to put their property back to the way it was before. And now, as we're fighting tooth and nail to get people paid, we've been fighting over, is that new law, does it go back? Is it retroactively applied, which means is it going to apply to all of the Hurricane Ian cases, or does it only go forward, which is a huge fight that we're doing as we sit here today. So now let's go back and look at what is happening right now in the insurance claim world with Hurricane Ian. So I know it hit September 28th, 2022, and we've talked about it before, but Hurricane Ian, which most people are not really aware of how deadly it was considered the deadliest hurricane to strike the state of Florida, and it was the third costliest weather disaster. We're talking billions of dollars between the flood and between the wind. And some of those numbers there was about, on average, 800,000 claims were filed, 800,000 of them. And there are still, these are average numbers that we're getting from kind of the public record, that the number of open claims are 50,000. The number of open claims without a payment is 25,000 claims. That is a lot. For a year and a half later, there are some that have had no payment done at all. The number of claims closed with payment are about 488,000, and the number of claims closed without a payment at all. That means they closed the claim. It means somebody filed a claim. If you're filing a claim, you're filing a claim. Why? Because you believe you have damage, right? You're seeing something, right? So that means you're looking at your property after the hurricane and going, there's damage here. And that's why you're filing a claim. Most people are afraid to file claims, right? Like, everybody, you may not have had a property claim before, but you've at least been an offender bender or any of those kind of things. And most people are hesitant to file claims, right? Because it gets used against them. They don't want it to be used against them. They don't want their premiums to go up. That's a huge thing we hear all the time. They're like, I'm so afraid my premium's going to go up. So for someone to sit there and feel like I need to file an insurance claim, it's because they believe they have probably extensive damage that at least goes higher than their deductible. Right? The deductible is the amount that you are responsible as the property owner to pay first. So if your deductible is $5,000, that means the first $5,000 of your damage you have to pay out of pocket, and then the rest of it the insurance company is supposed to pay. So to read that there were 196,000 claims were closed without a payment is preposterous, right? It's a crazy number to think.
That says 3 out of 10 without payment. 3 out of 10
3 out of 10 claims
200,000 claims
a property owner filed, and then the insurance company says, for whatever reason, we are not paying those claims. We're not paying anything. We're closing your file. That's another thing they'll do too. We're closing your file without a payment. So we're going to go to our first break, and when we get back, we will go more deep into what the new law looks like, how it's affecting the property owners, and what the claims are looking like today, a year and a half afterwards. Welcome back. Okay, so we were talking about all the closed claims without payments. So 196. So let's talk about some of the reasons why the insurance companies have been closing the files without payment. Some of the reasons that we've been seeing, some of the reasons for denial. Okay, the very, very biggest reasons we're seeing where they're closing these files is that there is a difference between flood damage and wind damage. And where it comes from is that the way it works, the difference between flood and wind, is if you have flood coverage, right? There are two different types of policies, right?
Right.
So if you have flood coverage, that's going to cover any water that comes from the ground up, right? We get this all the time where homeowners are confused about what actually constitutes as flood, as it being flood damage.
Especially when their adjuster goes in and says, oh no, this is all flood damage.
Oh yeah, and then they just believe it, right?
Right.
So we have one we were literally just looking at that is where it's 2 stories. Okay, 2 stories. The property is 2 stories. And they filed a claim for flood and a claim for wind. So it's 2 stories. The flood did come from an outside source, which means we're talking about that's going to be usually when you're near a body of water, when you're near a lake, when you're near a retention pond, if you have bad draining on your street and the water floods up, and that water that needs to flood needs to come in through usually underneath your doors, sliders. That's where that water, if it's flood water and it's going to be under your flood claim, that's where it comes from. It's coming from the ground, literally up. Now, wind is going to take into account your wind coverage. That's your homeowner's wind coverage. That's going to be when the water comes in through your windows, when it comes in through your roof, when it comes in specifically if you have 2 floors and you have anything that came into that second floor, it's more than likely going to be all your wind. So we've got tons of clients, but one of the ones where they have said, the insurance company, they love to do this. They love to fight with each other. You may have your flood telling you, your flood claim is saying, oh, this is really wind, while your wind claim is saying, this is really flood. And so that was one of the biggest denials that we saw. A lot of people who got denied for wind by saying that it was flood, which it clearly wasn't flood.
Right.
And so those are things we had to reopen those files and really look back into them and go, this is not correct at all. They're wrongful denials. So you got to make sure you guys are questioning that if that was one of the issues. One of the other reasons that we've seen denials where they're saying is that they're just plainly going out there and they see that you have damage, but they're saying, we don't believe that there's a wind-created opening in that roof that caused this damage. Or, what's another thing we see all the time? Wear and tear.
Wear and tear. Every single answer. Wear and tear.
Wear and tear. That is a huge thing that the insurance company loves to say, is they have to say, the property was old, the roof was old. How many times do we hear? The roof was at its end of its life.
My favorite is the foot traffic.
Oh, foot traffic. Okay, so this is another one that really it's sad, but we've laughed about it now because it's insane to hear. But a lot of the tile roofs,
yes,
that's where we'll see it the most on a tile roof, is that you'll have broken tile. And it can be chipped, it can be cracked, it can be literally, it can have a bunch of just crack marks and it's in pieces. So it can be lifted, a bunch of different things can be damage to your tile. But one of the denials that we see is that it didn't come from the wind. This damage didn't come from the wind. It came from foot traffic, which means people walking on your roof. And we like to say, I don't know if they were thinking that there was reindeer up on this roof, right? Because it'll be all over. There'll be broken tiles all over, and they're like, it's tons of foot traffic. And I'm thinking, where, in what neighborhood are these people at? They've got tons of people just stomping on their roofs, making all of this damage. Now, every so often, if maybe you had somebody go up there and check the roof, and
right,
maybe they cracked one of them when they were checking because you were having leaking. But it's another one of those reasons why they deny the claims, is saying that they believe that it was old damage.
Old damage?
Old damage. That's a huge thing.
If something looks like a repair, automatically,
yep,
you've repaired it before. This is
yep,
pre-existing. We're not going to cover it.
Yep. And it's mind-blowing to think that they would find that many reasons after a hurricane, right? Yes. So it's like, there's no doubt that the hurricane came through here. I mean, that's the black and white piece. So even in a hurricane situations, when we have claims there, they still find ways to say it didn't really come from the hurricane. It was already there, or it was wear and tear, maintenance. That's a huge one too, right? They'll say you failed to maintain this roof. You failed to maintain this. And that's really the reason why this damage happened. It didn't come from the hurricane.
Yeah. Where are your receipts for the maintenance for your roof?
Yeah, the maintenance, which I don't know who does maintenance on roofs. Not normally what property owner does, but most property owners do not do maintenance. I love it when they ask our property owners who are like, between the ages of 50 and 75, and they'll be like, well, was your roof, what kind of damage do you have on your roof before? And they're like, I don't know. I haven't been on my roof. They're like, well, what did you see right after the hurricane on your roof? They're like, I don't know. I didn't go on my roof after the hurricane. So those are some of the reasons why we've seen a a massive amounts of denials, specifically with the Hurricane Ian files. And you have such a high number of, unfortunately, as we've seen, wrongful denials. We have also seen a lot of denials based on what took place when they were getting their insurance, right?
Yes.
From the procurement of your policy. So those are a bunch of wrongful denials that we've been able to overturn, because there's certain, what they're saying in essence is they're going, oh, by the way, we forgot to tell you, right? They're not saying we forgot to tell you, because they're acting like they did tell you.
Right.
But when you got this policy a year ago, 2 years ago, most of the time a year ago, you didn't give us certain documents we asked you or your agent for. Like, what they do is when you get insurance and you go to your agent and you go, okay, I'm going to get insurance, the agent usually on a normal basis will get your information, and then they go ahead and put you with an with an insurance company, and they don't really do the full due diligence they should be doing. It's just
That's
not.
Correct.
I get it. It's hard. There's a lot of people who are getting insurance. There's not enough agents, and there's not big underwriting that's happening when it comes to residential, in residential property insurance coverage, But what happens afterwards is that once you go and file a claim, that's when they start looking into it and going, oh, did we get everything we needed at the beginning, or did we accidentally insure this property that shouldn't have been insured? And so, or they'll say, well, we sent you a letter, no one responded. So at the time you file a claim, we found a lot of people who were finding out they didn't even have coverage. That coverage had been rescinded because their agent hadn't given certain documents. Like sometimes they want an inspection report or a wind mitigation report. There's certain things that they'll ask for about the property. And so they'll say, well, actually, you don't have coverage at all, which we saw a lot of people who were in that boat. And some of the ways that we were able to overturn those are that the statute says there's certain things that an insurance company has to do in order to rescind, which means take back a policy they already gave somebody. Right. And a lot of those insurance companies had not done that. But there are people who've never called us, who I can only imagine were told, you didn't have coverage, sorry, you've got no claim here at all. And I mean, people were coming to us.
I'd like to know how many of the 200,000 that they closed without payment, they just told the people, you don't have coverage.
Yeah. Oh, I would love to know those. I'm sure those numbers are much harder to get, considering they're being held by the insurance companies.
Yes.
So those are some of the things that we do. Now, what happens if you are underpaid or denied and you believe you have damage? I'll start by saying, if you think you have damage and you filed a claim and you get an answer back from the insurance company that says you don't have coverage, we're denying it, question everything. Question it, right? You've already filed the claim. People ask us all the time. They go, is there going to be a penalty if I hire a lawyer, if I hire a public adjuster? Is there going to be a penalty for that? No, there's no penalty for you enforcing your rights to hire an attorney. You've already filed the claim, which in essence, the thing that could be used against you sometimes in this world of how they determine premiums for an insurance policy is going to be looking at how many claims, what kind of liability are you? How many claims have you filed? What have they been for? And what's the current status of your home? Have you repaired the property, or things that they're usually looking into? They're not looking into to go, well, did they get an attorney who sued us? So I can tell you right now, it's not going to be held against you anymore if you hire an attorney or a public adjuster or file a lawsuit or go all the way to the Supreme Court if you filed a claim. So if you filed a claim, you might as well exhaust all of your remedies, which really is hiring a public adjuster, hiring an attorney, because both of them work on contingency, right? You don't pay them unless you get paid. So first of all, if you file the claim and you get an answer back like that, call our office, call other offices, call their attorneys who do what we do, call public adjusters, and have them look over your file. That's number one. Number two is, if they did pay you, how do people realize that they are underpaid in an insurance claim? There are times when people know right away, right? Some people have been in the construction industry or have just got work done, so they know the cost of it. But majority of people have no idea. If I ask somebody on the street right now, how much would it cost to put a new roof on your house? They wouldn't know. They wouldn't know if it was $5,000 or $60,000 most of the time.
Right.
Because roofs, sometimes it's been 20 years since someone's put on a roof on the house. A lot of people buy houses already having newer roofs, so they haven't even thought about ever having a roofer come out and quote what their roof's going to be. But then talk about the interior, right? If I ask somebody right now, how much is it going to cost to water mitigate the entire inside of your house because you have water damage,
right?
To clean out the mold because now you're getting mold, to put it all back, right? To put all the drywall, the flooring, the paint, the texturing, any of those things. Oh, and if you have structural damage, you have any cracks, you need an engineer to figure that out. So you don't usually know how much it's going to cost to put your property back to its pre-loss condition, which is what the insurance company should be paying for when you have a covered claim. So the number one way most people realize that they've been underpaid, you can either call an office like ours, you can call our office and we do free consultations, which means we'll come out to the property or send somebody out to look at that property to see what your damage is. And we look at the paperwork from the insurance company and we can figure out if we believe you've been potentially underpaid or not. But most of the time what people are doing is they're calling a contractor. They're going, hey, I got my check from my insurance company. Can you come out and look at this damage? And then the contractor's getting out there and going, what is this? Whoa, what is this? They're like, there's no way we can get this work done for this. Like, it's impossible to do that. So that's usually where you start realizing that you've been underpaid for it.
We do have one client.
Yes.
$500,000 home.
Yes.
The amount of her damages is about $200,000.
Mm-hmm.
She's been paid $13,000
Yes.
and was told she was fully indemnified.
Fully indemnified, which means indemnified means that you've been paid the money you need in order to fix the damages. $13,000.
Right.
Sometimes it's so egregious like that it's slap in the face, and everybody wakes up around. Everybody can see it and going, okay, well, I may not know numbers. I may not know constructions, but I at least know $13,000 is not going to fix this property. A lot of people it was obvious for, unfortunately, but some of them it's not. And so what our office does, and what other offices that if you ever see the words that somebody does property damage insurance claims, or they also call it first party property claims, we're a very small group of attorneys that do what we do, and we focus on representing the property owner. You can hire us right when you file your claim. Some people hire us before they file their claim. They want us to look at it and see if they think it's a potential claim. You can hire us from beginning of the claim to any other part of it. You can hire it after you've already worked the claim yourself. A lot of people want to work these claims themselves, and they get frustrated and they work back and forth with the insurance adjuster themselves, because a lot of people don't know that you can hire help on a contingency. And then a lot of people hire us when they get frustrated and they go, okay, well, the insurance company is not paying me any more money, so now I need to hire somebody. And you can also hire a public adjuster. We've had public adjusters on the show, and a public adjuster is licensed by the state of Florida to represent a property owner against the insurance company to literally do an estimate of your full amount of damages and then to fight back and forth with the insurance company, but they cannot file a lawsuit. So that's when you need an attorney. So sometimes people hire public adjusters and you pay them a percentage, and then you hire an attorney who sometimes takes a percentage, or sometimes people hire attorneys only. And sometimes if you hire the public adjuster, they may be able to get it settled. So it's really kind of preference. A lot of people do kind of either or. But if you hire our office, we come out there, we do an inspection, we determine what we believe with our experts your damages are. We can do an estimate for the full amount of damages it should have been. And then we fight back and forth with your insurance company in order to try to fight to get you paid what we believe that you are owed. And if they don't settle with us in pre-litigation, then we go to litigation. So what was the benefit that we used to always have with going to litigation? If they didn't pay us, then we could file a lawsuit, and then the property owner was getting all the money they needed most of the time, and our attorney's fees were getting paid by the insurance companies.
Correct.
It was beautiful. But dun 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 dun. Welcome to politics, right?
Yes.
And it's not something I never felt I was good for politics. And that was mostly because of the fact that I feel like I'm I'm loud. I feel like I'm obviously an attorney, so I'm argumentative, but I also am very, like, what I say I mean, and I feel I'm very honest, and I'm moral, right? And so my morals come first. Money will never come before anything else. So I'm not willing to sacrifice that. And I feel like that's a lot in politics, right? What can someone do for somebody else? And you're willing to sacrifice your morals in order to politically do something. But I've learned a lot more about politicians more recently, that there are good ones out there that are out there really for the people, in order to assist them. So I've just stayed away from politics is what I've tried to do until I got in this area of law and politics started to severely affect the nightclub that my family owns. Like, that was huge. We've had issues with that. But really in this industry with these insurance claims, the law started to severely affect our practice, but really the people. That's what this law is going to do. And so
the insurance companies have great lobbies.
They do, right? They have a lot of money. What was the number that someone was just giving us? The numbers from the Super Bowl was like, I think they spent like $20 million on ads or something like that. State Farm did, and all the other stuff does, while they are daily denying claims that should be covered, underpaying claims that they should be paying more for. So they're putting a lot of money behind lobbying, and they're putting a lot of money behind commercials to create this rhetoric that they're your best friends, you're in good hands, like a good neighbor. Those are the things they're putting in your head. So when they say something to you, when they tell you it's denied or it's underpaid, you trust them because of this reoccurring concept in your mind from those commercials that they're gonna be there for you. But as we've seen, that's not always the case. So we're gonna go to another break. Stay with us right after the break, and we will continue going over where the claims are right now and what the new law means. Welcome back. Okay, so we're talking about the attorney's fees statute and the fact that what really even got me into this area of law was the fact that there was one-way attorney's fee statute. So if you sue an insurance company who underpaid your claim or wrongfully denied your claim, and if you recover money, then the insurance company has to pay the amount that they owe you, plus they pay towards your attorney's fees, which is absolutely huge, which allowed us to represent everybody on contingency. So people sometimes wonder, what does that actually mean? What does that mean when we're talking about the statutory attorney's fees? One-way attorney's fees is what the word is. So let's give an example. Okay. So let's just say that you are owed on your claim $50,000, which is an average kind of amount of a claim. So that will probably give you, if you've had a water leak inside the home. A lot of people have their lines, so their water lines underneath their sink will bust. They'll have a backup. Their pipes will collapse, and there'll be a backup in the home, and you get leaking from your sink or your toilet, or you have an insurance claim. But let's just say there's $50,000. That's what you're owed. And that is a massive amount of money. Okay, that is a lot of money that you're owed in order to fix your house. So $50,000. So the way it worked on, let's say $50,000 is that if an attorney has to take a contingency fee of that, the average contingency fee is 33%. 33%. Now, our office charges less than that. We just do, because we really truly want to make sure there's enough money to repair the property. But a lot of law firms will charge 33%. So 33% of $50,000 is $16,500. So in that instance, you'd be getting $33,500 would go to the property owner, and $16,500 goes to the lawyer. Okay. So that means your damage was $50,000. You're only getting $33,000. So you've got to make sure you're able to repair the property. The problem with that number in this situation is that if that means that's the most money this lawyer can get out of this claim, no matter how long they litigate the claim. So if this claim goes to litigation and it litigates for 3 years, 2 or 3 years, and it goes to trial, the most money the attorney's ever going to get is $16,500, which is why now, with the new law, most attorneys will not take any claim where there's money owed that's less than about $100,000. Because in that same scenario with the $50,000 that we're saying that was owed before, and now we've got our grandfathered claims from Hurricane Ian, the law that we've always practiced under in this instance would mean if you were owed $50,000 and we filed a lawsuit when we had the one-way attorney's fees, it was very helpful. We could argue that once we filed the lawsuit, that the whole $50,000 needs to go to the property owner, and our attorney's fees are in addition to this, depending on how long we litigate it. So let's say we litigate the case for a year and a half, and they finally settle, and our attorney's fees per hour that we should be getting paid come out to, let's say it comes out to $18,000, right? We've litigated it, we're preparing for trial, we're about to go to trial. We need $18,000 for our attorney's fees. In that instance, with the old law, the insurance company would pay $50,000 all to the insured, and they'd pay $18,000 to the attorney. So the insured was being made whole. So it was such a benefit for the insureds. But not only is it harmful for the insureds with the new way with there's no attorney's fee statute, but it also has now created, 'cause remember we talked about before, is that before with the old law, I could take a case where you were owed $5,000, $3,000. We have seen these people come to our office. $3,000 is a lot of money for people who live paycheck to paycheck, which is most people. $3,000, right? So you used to have a recourse. Like you could come to our office and go, I'm owed $3,000 for my contents. They denied it. They haven't paid it. Is there anything I can do with this? Absolutely. We could take that file and we could file a lawsuit against the insurance company and get you your $3,000, and the insurance company had to pay our attorney's fees. It was beautiful, and it's the way it should have been, right? Because this law that's very, very niche, not most areas of law all say everybody should bear their own attorney's fees, right? That's the old school, since the dawn of time, the way the law works is that it's very, very rarely where one person has to pay the other person's attorney's fees, unless it's like in a contract you signed or something like that. But in normal situations, it's not always included that way. But in this instance, it makes perfect sense because you're saying, Mr. Insurance Company, or Mrs. Insurance Company, you have not done right by me. You were supposed to pay to cover this because I was your client and I paid into you for all of these years, and now it's time for you to pay and you don't want to pay. So in that situation, it was like a punishment saying to the insurance company, and it was supposed to deter their behavior. That's what these one-way attorney's fees are. What the insurance company did when they were lobbying to get this law changed was they were saying, this is why the premiums are continuing to go up, is because of the attorneys filing these lawsuits. Well, I'm here to tell you today that if an insurance company believes it's a frivolous lawsuit, do they pay? No. They don't. They will fight tooth and nail, and they don't just pay out on claims because they're afraid of the attorney's fees. No. They were tired of being held responsible for the underpayments and the denials and their behavior. And they weren't liking the fact that now these attorneys were representing these clients and getting these claims paid, and it was cutting into their bottom line. And that's it. Because I'm here to tell you that if there's a claim that they believe is fraud, what do? They investigate it. They deny it. They will literally do anything. They have a whole entire special investigation unit is what they call it.
Right.
SIU, that these insurance companies have, where if they believe that you've committed fraud, they will make sure they come after you.
Yes.
So that's what they were really pushing, was that they were going to, that if they could get rid of these statutory attorney's fees, they'd be able to lower premiums. And here we are today, 2024. And we don't have a live studio audience, but if we did, we could say anyone whose premium has reduced, please give us a round of applause.
We'd still hear crickets.
We'd still hear crickets. No one's premium has gone down. It has not happened, and it's not happening. They are tripling. I mean, it's getting to a point where people cannot afford homeowners insurance. And it has nothing to do with the attorneys who are representing the people who are entitled to get paid. So what's going to happen now that people are just really not recognizing? Because the new law went into effect at the end of 2022. And it hasn't really hit yet. But what that means now with the new law, that there's not that statutory attorney's fees, is that if you've been underpaid anywhere from $1,000 to about between $75,000 to $100,000, it will be very difficult for you to find an attorney who will take that case on contingency, because they can end up losing money. Mm-hmm. Right. So right now, if you came to our office and you said, I'm owed, let's say $25,000, a lot of money. In our office, we do usually between 15 and 20%. That's usually where we're at. Now with the new law, we used to do only the statutory attorney's fees, right? We wouldn't even take a percentage. We would literally go after just our statutory attorney's fees if we had filed a lawsuit, and not a dollar would come out of your money. We do that every single day, all day. But now, going forward, if you come to our office and you are owed $25,000, which is what amount of money people would dream to have in their savings account. I mean, that is a lot of money. $25,000. If we took our 20% of that, times 20%, that's $5,000. That would be the max amount of attorney's fees we could take out of your money. That means no matter how long we litigated your $25,000, we would only get $5,000 in attorney's fees, which means we would lose money every time.
Yes.
It's heartbreaking, and nobody is recognizing that, because they won't know until another hurricane comes through and everybody tries to go get attorneys, and we're all looking around going, we want to help you. I want to help you. Our office will tell you, what are we doing? We've got litigation pits, right? Mm-hmm. How often late at night are we exchanging case law? I've got a great team at the Colucci Law Group that is constantly looking to find a way to fight this. And there are really strong advocates in our industry that are constantly fighting these laws. We're trying to find any way we can around it to help these people, because we can see what this impact's going to have very soon. If another hurricane hits, you're going to have anyone who has damages of $25,000, $30,000, $40,000, $50,000, $60,000 that you have not been paid. It will be almost impossible for you to find an attorney who'll represent you on a contingency. That's what that new law means. And nobody knows. Do you know what everyone was doing? They were celebrating when the law passed. Mm-hmm. Because the way that the state made it look like was that these attorneys were just rolling in the cash and taking advantage of the situation. And so they promised them, in essence, that their premiums were going to go down. No premiums have gone down. But now we still have this law sitting there. So one of the things that has been a fight about the new law was when it passed in the end December of 2022, the question was, is it retroactively applied? What does that mean, Kelly? Retroactively applied? Because that's what they wanted to do, right? They wanted the law to start literally immediately. Upon signing, they love these laws to start right then. So that means anyone that files a lawsuit after that date, it doesn't matter how old the claim is, how new the claim is. If they filed it after December 2022, we filed a lawsuit, that case should not have statutory attorney's fees.
They actually want that every policy they have ever written in perpetuity to have all of these new rules.
Yeah. Which is unfair.
It's absolutely unfair.
Yeah. Which would have, let me tell you what that would have meant. There are a lot of claims that we've taken that are small amounts. We have claims for associations that are multi-million-dollar claims, but we also represent the people who have small claims, a little amount of money, and we see them all as
only need a roof.
Yeah,
that's all
only
they need.
A roof, right? Only need a roof. And I mean, on houses where roofs are, we've got some roof claims that are $13,000, $10,000. We have people whose contents were destroyed and they lived in a condo, and they've got claims for $8,000 where it's just been denied. We've been able to take all of those claims, which we've signed them up, which we've been working on them for the past year and a half, and they wanted that new law to go into effect for anybody who the lawsuit gets filed afterwards. That would mean we'd have to get rid of those. We have to fire those clients because we couldn't file a lawsuit. We've already been working on your claim, and we haven't been paid on it. Now we're going to a litigation, and we can't file a lawsuit because we're not going to get attorney's fees. And the most we can get is a percentage of your money, which is not going to be enough with how long we're potentially going to litigate this case. So it's very, very detrimental if the law goes into effect and starts that day for any lawsuit that's filed. So what was the big argument that we all started arguing? And we have made really good headway. So right now we are in a comfortable position that now the law does not apply to policies that were written afterwards, right?
Right.
Yeah. Or written before.
Written before.
Yeah.
We have one Hurricane Sally that I'm working on right now,
Yep.
where after 2 years of litigation, now the insurance company is saying...
It's horrible.
Is saying now you have to file an NOI.
Yeah, they want us to go back.
A notice of intent to litigate. But there's case law that is all over the place about all of that.
Yep.
They have one DCA that says you don't have to file these and that it is not retroactive.
Yep.
You've got the Supreme Court that says that it is not retroactive. There is no intention by the legislature to make it retroactive. Mm-hmm. And then you have other DCAs, appeals courts, that are actually saying, yes, it is retroactive.
Welcome to the world of law, right?
So
we got all these different court
place.
levels. Yeah, because everyone's, and that was the thing too, is that they were hoping this was going to lead to less litigation, right? These new laws. We have litigated everything. And let me tell you, I have never seen something so unfair legally when it comes to an insurance claim than I've seen right now with the new laws they're trying to apply going backwards and even potentially applying going forwards because of what that damage is going to look like. So right now, what we can tell you as we sit here today is that if you have a Hurricane Ian claim, if you have any claim that you have filed before December 2022, we are still comfortable sitting here today telling you that you still have statutory attorney's fees, which is a good place to be in, which means if you have a Hurricane Ian claim and you believe that it has been wrongfully denied, you believe that you've been underpaid, or you're just not sure and you want us to look at it for free, we will do a complimentary assessment of your damages, of the letters that have been sent to you. You don't wake up becoming an expert in insurance claims. I didn't. We all had to learn this. Like, that's literally what it is because we specialize in it. But it's very complicated for a reason. You have 80 pages on an insurance policy, and how many people have actually read that? Our law firm has. We have. But most people absolutely have not read that. So it is confusing, in my opinion, by design. But don't feel like you have to weather the storm alone. Don't feel like you are in this by yourself and have to figure out what they're saying. Does it make sense? What's the law that applies to it? Question everything and reach out to our law firm, and we will look at those damages for free because we are still finding people. And I saw this a lot when we were helping in Louisiana, where people, because there's several hurricanes that hit there all the time, where we're finding out, we meet people who tell us that, well, the claim I had before, I didn't know I could hire anybody, so I cashed in my 401k. I went through my savings. I went through my child's college fund. I swear to you, it has broken our heart because people don't know that we exist and that we can look at this absolutely complimentary. So if you want us to look at your case, reach out to us, 727-733-9438, or send an email to office, OFFICE, at Colucci, COLUCCI, Law Group, LAWGROUP.com. After I created all of those websites, email websites, I realized I should have made them a lot quicker and smaller. So when I say them over the radio or a podcast, it's very easy. It should have been like CLG.com. Yeah, hindsight's 2020. So thank you guys so much for joining us today as we talk about where the insurance claims are at and just reminding people that, listen, you still have time. You still have time. It is not too late. You've got, technically, with the old Hurricane Ian files, you have 5 years. 5 years. I'm putting up both hands, which means 10. 5 years to file an insurance claim lawsuit. So which means we have a lot of time on these. Make sure you're mitigating your damages, which means to make them less.